Hi, welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. I'm your host, Nikki, and this is episode 14, North Carolina versus Butler, decided in 1979. A quick note before we get started. As always, we try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. Okay, with that out of the way, let's start the show. I cannot segue off of that. I'm waiting for a good moment, and it just gets worse and worse. So hello there. Welcome to the Relitigated podcast. I'm your host, Nikki, and I'm joined by my co-host, Jarrett. Say hello, Jarrett.
Hello.
We also have with us three friends who will be role-playing as our justices. First, we have Associate Justice Mike.
Hello.
Next, we have Associate Justice Graham.
I'm the king of roleplay.
And lastly, we have our Chief Justice Adam.
Whoa, hold up.
I don't know what we've done.
Thank you so much. Also, I resent the notion that I'm role-playing.
If you're new to the show, here's how this works. Jarrett and I have selected a real Supreme Court case, and our justices do not know what case we have selected. Jarrett will introduce the case to us and walk us through the facts so we can all get familiar with the details. The justices are free to ask factual questions during this time, and we will answer as best as we can. Next, we'll move into oral arguments, where I will roleplay as the petitioner and Jarrett will roleplay as the respondent. We each get 7 minutes to make our case, during which the justices can interrupt us and ask probing questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if two or more justices agree in principle, they can disagree as to why. Once we've had our fun with our mock hearing, Jarrett and I will reveal what the Supreme Court really decided and talk about how we feel about the actual results and why this case matters. Sound good to everyone?
Just like the real Supreme Court.
Oh, yeah.
I love it.
Well, then I'll turn it over to Jarrett.
Thank you much, Nikki. For this episode, we will be retrying North Carolina v. Butler. Our case begins at a gas station in Goldsboro, North Carolina, where two men are robbing the establishment at gunpoint. As the station attendant attempts to escape, he is shot and ultimately paralyzed by his wound. A week later, the attendant identified his assailant as WB, and a fugitive warrant was issued for WB's arrest. Ultimately, the FBI finds WB in an apartment in the Bronx in New York City. According to WB, they entered the apartment at 6 a.m., woke him up, and read him his rights. Specifically, the FBI agent read the following from a card. Before we ask you any questions, you must understand your rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions and to have him with you during questioning. If you cannot afford a lawyer, one will be appointed for you before any questions if you wish. If you decide to answer questions now without a lawyer present, you will still have the right to to stop answering, and at any time until you talk to a lawyer. Now, anyone who has turned on an American television in the past 40 years has heard this spiel before. Of course, this is known as the Miranda rights. This case is not the Miranda case, but Miranda is relevant, so I will provide a little bit of info about it at the end. For now, though, we return to the Bronx, or more accurately, New Rochelle, New York, which is where the FBI next took WB for questioning. Once in an interview room, WB allegedly told the agents that he completed at least 11 grades of school, so the agents considered WB to be literate and gave him an advice of rights form.
Objection.
This form is...
Were these continuous years?
What?
Continuous years of school. 11 years? 11 years of continuous school?
He
Doesn't
completed
say.
the 11th grade, essentially.
Okay.
So this form, the advice of rights form, is basically a restating of the Miranda rights, and it has a space for the suspect to sign at the bottom in order to acknowledge that they will answer questions without a lawyer present. According to the FBI agent who testified at his trial, WB affirmed that he understood his rights, and when asked to sign the advice of rights form, replied, quote, "I will talk to you, but I am not signing any form." The FBI then reminded WB that he did not have to speak to them without a lawyer, and he said again, "I won't sign the form. I will talk to you, but I won't sign the form." After that, WB went on to tell the FBI that he and the other man accused of the robbery had been drinking that day and did discuss committing the robbery. He also confirmed that he was at the gas station at the time of the robbery, but he asserted that he did not actually take part in the robbery and was not the one who shot the gas station attendant. Fast forward to WB's trial back in North Carolina, and his defense lawyer moves to have the FBI's testimony from WB's interrogation excluded from evidence. They argue that WB never explicitly confirmed that he wished to waive his right to counsel. In other words, he never signed the form confirming he understood his rights, and he never said out loud definitively that he did not want a lawyer. The trial court denied the motion and allowed the interrogation findings to be entered into evidence. At the conclusion of the trial, WB was convicted of robbery, kidnapping, and felonious assault. WB's defense appealed his conviction to the state Supreme Court, again arguing that the FBI's interrogation violated his Fifth Amendment rights. Since WB did not explicitly say or indicate that he was waiving his right to counsel, anything he said to police without counsel present should be excluded. And the North Carolina Supreme Court agreed, arguing that the ruling in Miranda v. Arizona meant that the government needed to secure explicit waivers of rights in order to use any interactions as evidence. Of course, the state of North Carolina appealed this decision straight to the Supreme Court, and it now comes before us. So, justices, the question for this episode is, does the Miranda ruling require an explicit waiver of one's right to counsel?
I love a good loophole, and I feel like we found a really valuable, exploitable loophole right here.
I feel like after several episodes on this show, I'm going to be really good at getting away with crimes.
Yeah.
Just on technicalities.
I wonder if judges ever sit there and think about like how good a crime they can get away with. Bet they do.
Can't stress enough, like we do at the beginning of every episode, that nobody involved in this is a lawyer, and that nothing we say should be taken as legal advice.
Part of fancy law training is knowing what not to say.
Yes.
I think another season goes by and we probably get our honorary, law degrees, and probably the
we're
bar
at like
just lets
least
us in.
clerks or something. Yeah.
Yeah. Real quick, I promised earlier to do a bit of a refresher on Miranda, and I know that we've all heard of it and we've all heard the Miranda rights spiel a million times, but it's important to know the actual specific outcome of the case because that actually gets talked about seldomly.
You know, like most topics on this show, the majority of my understanding on this comes from Law and Order, so that would be welcomed in my court. Thank you, sir. How do I address you? I know how you address me.
Counselor,
I
guess.
Please refresh us, counselor.
Yes. So there's actually a lot of parts to the decision, and I'm going to crib directly from Justia's summary just to keep things brief. So shout out to Justia for this, but even making this brief, it's going to be a lot. So apologies in advance. But here we go. First, quote, "In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privilege must be observed. The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation, and that, if he is indigent, a lawyer will be appointed to represent him. Second, if the individual indicates, prior to or during questioning, that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, The questioning must cease until an attorney is present. Third, where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his right to counsel. Fourth, where the individual answers some questions during in-custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. Fifth, the warnings required and the waiver needed are, in the absence of a fully effective equivalent, prerequisites to the admissibility of any statement, inculpatory or exculpatory, made by a defendant. And lastly, the limitations on the interrogation process required for the protection of an individual's constitutional rights should not cause an undue interference with a proper system of law enforcement, as demonstrated by the procedures of the FBI and the safeguards afforded in other jurisdictions. And while this is not everything said in the Miranda decision, those are the main bits. Does anyone have any questions about that or want me to reread any of it? I know that was kind of a lot.
I know I'm a fancy Supreme Court justice and all, and it's been a minute since I've been to law school. Could you explain to us what exculpatory and inculpatory are?
So inculpatory is basically something that incriminates somebody or is evidence that they committed the thing. Exculpatory is evidence that helps clear them.
Oh, okay. I think I understand all of this, yes.
Let me see if I can summarize some of this Miranda stuff. So we know the Miranda rights spiel, you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney, blah, 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 all that bit. And then some of the other pieces here are, if you start talking, you haven't actually waived your rights. Technically, you can always reassert those rights. It's just whatever you said, right? That's on the record. But at any time you could shut up, or at any time you can ask for a lawyer. And if you do, then the questioning has to stop and they have to either get you a lawyer or wait for you to decide to talk to them again.
And Miranda has nothing to do with what you as the suspect actually do, other than you're willing. You can talk freely, but it has nothing to do with like whether you're cooperative with the process or not. It has nothing to do with whether you assert affirmatively you want a lawyer or not. It just has to do with the way that law enforcement has to regard the evidence that is taken during your captivity.
Yeah, so it's basically requirements of the police for them to inform suspects of their rights before taking any kind of statement.
Yeah, but it's not in any way contingent on whether the suspect is actually cooperative with the process or not.
No, it's just saying, I think it's just saying, like, yeah, cops, you gotta, because the case that started it was a guy who said stuff because he didn't know that he was allowed to just not.
Yeah. And I think the important thing here that might, or I think the important piece of Miranda, especially for this case, is this idea that ultimately what the prosecutor wants to do is get your testimony to police during questioning entered into evidence.
Mm-hmm.
And what the Miranda case said was there are some steps required of the government in order to make that testimony valid to be put into evidence. So it raised the bar on the government and on law enforcement to say, like, look, you got to do some stuff in order for that testimony to be entered into evidence. If that stuff hasn't happened, then, it's no good. You can't use it.
Let me ask my question in a way more pointed and ridiculous way. If I get arrested and I just pretend I'm a dog for 3 days and refuse to assert that I want a lawyer, it's not like that can just stop the legal system from proceeding with trying to prosecute me.
Oh yeah. That has to
Yeah.
do with the admission of your statements, but because this comes up sometimes where defendant will be like, oh, they never gave me the Miranda rights, and maybe
Got to start over.
and it's like, oh, that you can't try. And it's like, well, they found you holding the gun. It was smoking. There was a guy who was shot, and he pointed at you and said, oh, that guy shot me. And then there were 8
Yep.
witnesses and cameras. The police don't really need to get a statement, but if they wanted a statement, then they'd have to, do the whole spiel. But
I feel like this will be relevant later.
If
Yeah.
I know that the Miranda ruling protects you for, using what you say as, as evidence, but are the police or law enforcement allowed to use what you say? Are they allowed to use it to gather additional evidence and then not use what you say, but use the additional evidence that they gathered? Or is that, they can only use if you are not ready your Miranda rights, they can't use anything that you say.
Your statements can't be used against you in court.
I see. I enjoy that answer.
Yeah, there's a lot. We're not doing Miranda. Miranda's a very famous case, so we all kind of know what the outcome of that
Right.
case is. So we're never going to do an episode on Miranda, but this case hinges on Miranda, and so we actually kind of have to go through it, and it's kind of a lot. Like I think it's way more. Certainly, when I was reading through it, it was way more than what I assumed it was. Like I summarized a lot of it. Or I stole Justia's summary of a lot of it. It's a long decision.
Mhm.
There's a lot of ins and outs. It's interesting. You should go read it. You should know it as an American citizen. But it is just the foundation upon which this case is now gonna.
Yeah, our fight
Hinge.
today is about how we read this case in police doing things.
Any other questions, factual in nature, that Nikki and I can try and answer for you?
I mean, I have a lot of questions, but none relevant to the case at hand.
All right. I believe, Nikki, you are going to be the petitioner on this one. You'll be representing North Carolina.
Yes. The state of North Carolina, or the prosecution, essentially. All right. Has my time started yet?
7 minutes is on the clock.
Okay. Mr. Chief Justice Adam, and may it please the court.
Oh, I am pleased.
Issues with the Miranda warnings have come up time and again across the United States. But North Carolina is singular in its interpretation of the Supreme Court ruling and completely out of step with how we understand the warning and its purpose. North Carolina is locked into one rigid interpretation, reading things into the decision that were never intended. So, North Carolina is stating that to provide information, an individual absolutely has to sign something or to make an explicit statement. In this case, the individual was advised of his rights, both orally and in writing. The police never lied to him about his rights. They never forced him to participate. After being informed of his rights twice and reminded that he could have a lawyer present, WB said, quote, "I'll talk to you." He said it twice. Regardless of his refusal to sign the form, everything about this exchange makes it pretty clear that WB did not wish to delay or cease questioning. He clearly chose to waive his rights, and he voluntarily spoke with law enforcement. The prosecution, in proving that WB was given the warning and that he knowingly chose to proceed, has done its job. There is thus no reason for his statements to not be admitted, and this was the finding of the trial court. The North Carolina Supreme Court is relying on an inflexible and frankly unworkable rule that disregards the circumstances, gestures, and words that regularly inform interpretation of regular human communication. There is no requirement in the Miranda decision that a person has to sign a stack of legal documents or recite a precise magic incantation. That is not what this is about, and North Carolina has lost the forest for the trees. The point of Miranda is to ensure that a suspect is notified of their rights. This way, in their interactions with police, they can make informed decisions about whether and how to proceed and do so voluntarily. Miranda focuses on this substance, while the North Carolina Supreme Court is fixed on the packaging. In this interpretation, the North Carolina Supreme Court changes an eminently reasonable protection that is afforded all of us by the Constitution into a ritual divorced from meaning and into overprotection that encroaches upon autonomy. Protecting the defendant from his own intelligent decisions is unnecessarily paternalistic and totally undermines the principle that individuals should be free to make their own choices. In a case such as this, where the individual is informed of his rights and opts to speak, the Supreme Court essentially deprived him of an opportunity to make a decision and to take the action that he chose voluntarily. The Fifth Amendment says that a person cannot be compelled to be a witness against himself. Just because WB did not like the consequences of his decision does not mean that he was subject to law enforcement malfeasance. The investigators never forced him to speak. They provided him with ample opportunity to consider his choices and never engaged in any action that overcame his free will. Even if he voluntarily incriminated himself, there was no Fifth Amendment violation. The Constitution entitles us to protection from government intrusion and overreach, but does not promise us hand-holding and paternalism. And with that, I yield to questions.
Is this bait? This feels like bait in our current political climate.
Bait in what sense?
Like you're giving us a real easy slam dunk for the prosecution here.
Yeah, I would like to hear the defense.
I'm looking forward to what Jared has to say for himself. What have you gotten yourself into this time, mister? I don't have any questions. This feels frighteningly clear cut to me.
Yeah, it's too straightforward.
Mm-hmm. Yeah,
it does feel like a trap.
Where's the twist?
Well, it is a simple, straightforward question, honestly.
This also seems very similar to the last one the three of us were judges on. Is this a theme? Is this purposeful?
This is actually an elaborate version of that test in Blade Runner to see if we're human. This is the first for me. I don't think I have any questions.
That other case was in North Carolina too, wasn't it?
The cops there have a way of abridging people's rights.
Wait, which one? There were a few North Carolina cases.
Yeah, North Carolina popping off.
HA with the Alford plea.
Yes,
that was North Carolina.
I am curious. What is this form? This form that he was asked to sign? This is a federal form.
Yes, and it basically lists out the rights, the Miranda rights.
When did that become a thing after the Miranda decision? Like, when did they decide, like, we need to put this in writing? We need a memo for this?
Probably immediately. It's pretty. I would imagine the practical thing to do would be for police departments and authorities to just have a thing in writing and then give it to cops, like, read this.
I have a lot of things I feel like I can say right now that I'm not going to say.
Don't embellish. Just read what's on the paper.
Just seriously, just follow the damn script.
Yes.
All right. I just want to say the Supreme Court justice rests.
All right.
That's convenient because that's 7 minutes.
All right. My timer's booted up and ready whenever you want to start.
All right, here we go. Mr. Chief Justice, and may it please the court.
It does.
I appreciate that the state of North Carolina or other states feel like obtaining an explicit waiver of rights from a suspect feels like oh so great a burden. But this burden comes straight from this Supreme Court in the Miranda v. Arizona decision. Remember, in that case, Chief Justice Warren wrote, and I quote, "If the interrogation continues without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his privilege against self-incrimination." An interrogation and questioning while in custody is an inherently coercive situation. You are stripped of your freedom and autonomy. You are put into an uncomfortable position where you are dependent on your inquisitors for everything. Want to eat? Want to use the restroom? Want to go home? It's their rules and it's their game. It seems only fair that with all that power and control, that the state be required to get explicit acknowledgement from a suspect that they wish to waive their rights before they ask their questions. If we allow for implicit waiving of rights, that means we're asking the police to decide whether a suspect has waived their rights or not. That shouldn't be up to them. This case is a prime example of how little we can trust law enforcement's powers of deduction. They decided that the respondent was literate, but they conducted no tests to prove that assumption. They gave the respondent a piece of paper that explained his rights, and the only thing they asked him was, "Do you understand?" But they never asked a single question to test his understanding. They just took his response at face value. And why would they test it any further? That would be work, and it might disprove their assumption. Then they asked the respondent to sign the document, which would be the only piece of physical evidence that would prove that the respondent was actually waiving his rights. And what did he do? He refused to sign. This was an explicit signal that he either did not understand his rights or he did not agree to talk on the record with law enforcement without a lawyer present. Either way, the fact that these are possible scenarios proves that trusting law enforcement to make these kinds of decisions is a mistake. But of course, this blatant piece of evidence, this refusal to sign, did not confirm law enforcement's assumptions of the respondent, so they just ignored its significance. Tell me, do the actions of the respondent appear to you to be the actions of a man who understood knowingly and intelligently his rights? Isn't it equally likely that he believed that not signing the waiver meant that he was not explicitly waiving his rights? The police have a vested interest every time in believing that you know what's going on. After all, they're not the ones under pressure in that situation. Can you imagine being woken up at 6 a.m., dragged out of bed, handcuffed, driven away to a claustrophobic interview room where you are watched and questioned? Every one of us here would struggle to keep things straight in that moment and that environment. For the officers, just another day at the office. If the Fifth Amendment means anything, and the Miranda v. Arizona decision means anything, you must side with the North Carolina Supreme Court. It is good and necessary step to make law enforcement get an explicit acknowledgement from you that you are waiving your rights before they ask you questions. Otherwise, we're just letting them decide whether or not you're waiving. It's good for the courts because it removes the burden of having to interpret law enforcement's interpretation. And finally, it's even good for prosecutors because it removes doubt from the foundations of their case. This is a good thing for society. Make the government ensure that you are explicitly not using your rights anymore, that you have explicitly waived. It's not difficult. If somebody doesn't explicitly indicate to you via signature on a form or oral statement that they are waiving their rights, don't assume they're waiving their rights, period. The North Carolina Supreme Court got this right. I trust that you will too. Thank you, and I yield to questions.
This entire goddamn thing's a psyop. Turn me conservative. Convinced. Okay, so the Miranda rights start with like the first few words. It's literally the first thing they decided to put in the thing is you have the right to remain silent. But it's not the obligation to remain silent, right? Like, what's the difference? Like,
the difference is
are you implored to exercise your right to remain silent, or is it just like, it's an option you have?
the point here is that they are trying to enter your statements into evidence to be used against you. They are compelling you in that scenario, if they enter it into evidence, to have you testify against yourself. And our argument is that the bar for entering that into evidence should be that some indication that you explicitly waived that right. Otherwise, we're assuming that you did.
Isn't speaking after you've been told you have the right to remain silent an explicit waiving of that right?
No, because it has to be knowingly and intelligently waived. Somebody who just is speaking, we didn't interrogate to determine their level of understanding. They could have a mental illness and they're just speaking. Or they could just straight up not understand what that means. I would hazard by the numerous examples of citizens just talking to the police, even if it was not in their best interest, that Americans don't have the best understanding of what the right to remain silent means. And
all right, nice work. I'm liberal again.
I think it's contingent on the government to get that explicit acknowledgement and to test and make sure they collect evidence. That's what they do. They should have to prove that as well.
So out of curiosity, in this case, what would reach the bar of the explicit proof? Because they said it a bunch of times and the guy said, okay, I'm not signing. Should they just be like, okay, we're not going to listen to you? Like, what's the...
He's a genius, sir. He's found the one loophole. We have to keep him forever.
I guess
they should have been immediately
clarification
suspicious
on what explicit is, I guess.
Yes, right. They should have been suspicious that that he wouldn't sign the form that acknowledged his rights, and that says on the form, I understand that I'm talking to you without a lawyer and I'm approving that. He did not sign that. He would not sign that, which means he would not put his name to that statement, but yet continued to talk to them. At the very least, that shows that he may not have had an adequate understanding of his rights, which is exactly what Miranda is for, is to make sure we have an understanding of our rights.
You are out of time.
All right.
Man, justice is on a strict time limit.
You can give me more time if you want.
We run a tight ship in my court. Justices, do you have any further questions?
I just don't know where y'all get off trying to make me pro law enforcement.
Right? I'm sickened by this.
What the hell is going on? This is nonsense. Where does it end? This man has to sign a piece of paper for it to be admitted into evidence. I understand the overarching theme of we need to make it difficult for law enforcement. We need to put as many checks and balances in place with law enforcement as possible to ensure that they aren't putting innocent people in prison and that you're innocent until proven guilty.
But now you get paperwork involved.
But the man has to sign a piece of paper, and if he decides not to sign a piece of paper, then just whatever he says goes, or it is not admitted. I tend to lean into the slippery slope idea of like, where does this end? What at some point we have to draw the line, and making this guy, Jarrett made the point that because he did not sign, that that means that he could not have, like, there's a potential that he didn't understand his rights. I think that because he didn't sign, he didn't sign because he knew he was guilty. He didn't sign because he knew it wasn't good for him. I think he very much understood his rights. So I'm frustrated with this whole operation. I can't believe that I have to be on the side of law enforcement on this. It's preposterous and ridiculous and disgusting. Yep. And I yield my time.
I think we moved right into deliberation with that one. There was no question. There was no question in there for me.
No question.
That was more of a statement. So.
Sorry, I had to get that
soliloquy.
I'm still curious for, in this particular case, what the explicit waiving, what in the cop situation, what would be the correct thing in this case? that would satisfy that?
I think it could have literally asked one more question and just said, "Do do you wish to speak to us without a lawyer, understanding that whatever you say to us, we will use against you in a court of law?" And if he had said yes to that question, right? Just one additional question, I think would have done it. But
I'd be
they
like, you asked me like 8 times already.
but that is a very specific question that gets at understanding.
So, okay, so the first reading of the Miranda rights, when they're like Law and Order style at the scene of the arrest, that's just to broadcast it, make sure you heard it. Later on, they got to gather the actual proof that you understood it and like internalized it. And then they can interrogate you if you're like, yeah, I get it. I'm a cool guy though. No lawyer for me. I'm going to represent myself. I got ChatGPT.
I mean, I'm out of town out of time, but I'll just say one more thing. I mean, they could mumble the Miranda rights. They could like all the if the bar is just I said the magic words, as opposing counsel said, the magic words enables
You said that
law
very
enforcement
dismissively.
enables law enforcement. So now there's no magic words that protects the suspect, but there are magic words that protect the law enforcement and what they intend. Come
You better watch it, buddy. I can't hold you in real contempt because I ain't got no bailiffs, but I'll hold you in personal contempt.
on.
So we don't have. I do have a question. We don't have any evidence that law enforcement asked him that specific question. They just beat around the bush, if you will, and
No, they did.
Wait.
They asked like a whole bunch of times.
Okay, this is a factual question, so I will answer this question,
okay,
even though
please.
this has nothing to do with my time. I'm in clerk mode now.
Yeah.
According to the transcript that I read, and Nikki, you can weigh in on this too. Keep me honest. The the FBI agent who testified, never said that they asked a question like the one that I just posed, right? Do you want to talk to us even knowing without a lawyer, even knowing that anything you say to us we were going to use against you in court? They didn't ask that question. I think the question that they asked was, do you understand your rights? And do you want to talk to us?
In between swings of the truncheon.
And so did he? What was his? So it says here that he affirms that he knows his rights. So they asked him, "Do you understand your rights?" And he said, "Yes."
Yep.
Or I think, was it he nodded?
He provided an affirmative indication, I guess we'll say.
Maybe he was just being a people pleaser and just saying yes because they asked him.
But would not sign any forms. I feel like I need to hear the tape. Is there a tape?
Yeah, like
Can we hear the tape?
how belligerent he was being in the moment might play a huge factor in whether.
I mean, I just want to know exactly
police-
what the FBI agent said and exactly how he responded.
Exactly,
there's
right.
probably
like,
some important context in that,
Like if they said like, "Do you understand your rights?" and the answer was like, rah, 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 like Tasmanian devil sounds, like understandable that. So we're missing context without the tape of
but I
what
think
actually was said in the room.
if he just nods and keeps talking, or if he says yes, I understand, and then that's different.
That's a good point. Maybe he was
if
just
you give me a
nodding
second, maybe I
continuously.
can try to pull it up. I can go onto OEA and kind of see. It might take a minute.
Powers?
Yeah, I can pull up the transcript of the hearing where they
because I feel like even asking the question that Jared said to ask, I feel like an affirmative answer to that still could be him not understanding.
He took 11 years of consecutive school, though, so
that's true.
Okay. So it says he got the form, he read it. When asked if he understood, he replied that he did, and then he wouldn't sign. And then they were like, "Okay, but you don't have to talk to us. You don't have to sign the form." But the agents would like to talk to them, and he said, "I'll talk to you, but I'm not signing any form."
Did he say why he wouldn't sign it?
I don't believe so.
He probably rightly assumed it would introduce ambiguity into the proceedings. Perhaps,
Well, other way around,
Yeah.
it would reduce ambiguity.
I think he perfectly understood.
his case made it to the highest court in the land. So,
Like why would you? Well, here's what I don't get. Like why would you say I'm not going to sign the form, but then say all that stuff?
that does actually lend itself to the argument that he was not competent and did not understand what was being asked of him.
Let's see. So it said, okay, so he asked if he understood it. He replied that he did. He wouldn't sign it. Let's see. Respondent was in the possession of his faculties and did not appear to be under the influence of alcohol or narcotic drugs. Told him he had an 11th grade education, appeared to know what was going on about him, appeared to respond to questions in sequential fashion.
I guess my question is, how do you prove that somebody understood something? Because I guess that's what we're asking here, is we're trying to figure out if we can ascertain if this man understood what he read and understood when he answered in the affirmative exactly what he said. And I think that
should probably make him sign a form or something.
Yes.
And we're full circle.
So I should the FBI have just said, like, look, if you're not going to sign this form, we're not talking?
Yeah, I guess can you just not do anything until the court appointed lawyer shows up at that point?
So that's an interesting thought. The idea, okay, if there is a form, but there's an option for the form not to be signed, but that might not matter, then what's the point of having a form? Like, that's an interesting point, Mr. Chief Justice. The idea of, if there is a form, it needs to be signed before we talk. If there's not a form, then we don't necessarily need that. But because there was a form that's not signed, God, y'all pick great cases. This is fun.
Porque no los todos, they all go to jail.
Everybody's guilty. Sad but true.
Including us, the four of us.
We're all sinners, really.
Greatest El Salvador.
Yep. Porque no los todos? Is that our new doctrine?
I do think it's interesting, though, that that WB confirmed that he was present at the gas station. He confirmed that they discussed robbing it. He then did not confirm that he participated in the robbery or the shooting, and he also knew not to sign the form. To me, that sounds like somebody that knows exactly what's going on.
All I'm guilty of is giving that guy a really good idea. That's all I'm saying.
This is weird, because he did say that I do understand. Like, if there was no indication that he answered that question in a actual affirmative, like if it was just a nod or he didn't answer it and kept talking, but the fact that he said that he understood it and then said, "I'll talk to you, but I won't sign any." Man, maybe he just doesn't know what the hell's going on. Maybe he's just an idiot. Maybe that 12th year really is important.
It's when you take civics and that kind of thing. Yeah.
Either he was the smartest guy in the room or the dumbest guy in the room.
I agree with Jarrett that we need I think some sort of explicit confirmation that they understand the rights should be required. But in this case, I don't know if, I was going to say it sounds like it was explicit, but then his actions confer that maybe he didn't know what the hell was going on.
Well, if he reads a form and says, "I understand this," and then doesn't sign the form, it's almost.
Have you ever met an illiterate person? They really good at hiding the fact that they don't know what the heck they're reading.
I feel like by the time we get to this point in deliberations, we usually have some sort of fire underneath us in one direction or another, but this one is confounding.
Yeah.
I've whipsawed back and forth a couple of times on how definitively I feel like I can rule on this. I think we've all learned something today. I'm not sure what it is, but yeah, far be it from me to want to give the police expanded power to interrogate, but you really do have to respect asking somebody, do you understand? Will you sign this? No. Like, it's kind of a binary, right? Like, you either sign it or you don't. Signing is yes, and not signing it is no. And yeah, I'm just rehashing now.
But he wasn't signing it because he didn't understand. He didn't say. Did he ever say why he wasn't signing it? I feel
That
like
feels
that would be the
important.
kicker
Yeah,
here.
we'll never know. But
I think that's a question that people generally don't ask.
Yeah, to my knowledge from research, he never stated why he wouldn't sign it, and there's no indication that the FBI ever asked him why he wouldn't sign it.
Feel like that was a misstep. So it never even came up, like in the appeals getting to the Supreme Court. Like no one along the way asked, why didn't you sign the paper?
Well, once the conviction happens and it gets appealed, there's no new information. As far as I understand the process, the appeals court gets only the information that was available at trial.
Yeah, they just get like a record, and you can't like go back and get.
You can't like bring
new-
someone in for like.
Yeah, there's
questioning
no
them.
investigative portion of the appeals process.
It's just like here's the information we have in front of us. Oh, you want more? Sucks for you.
This is why you might sometimes have heard of like, oh, why would this defense lawyer have asked this or that? And it's like, because they're setting something up for appeal. So it has to get a record in so that it can be used later.
I would like to apologize just quickly to everybody for my beginning soliloquy because I might have a different opinion now. I just want to put that on the record. If we're, Chief Justice, you mentioned at this point we usually have some sort of idea, and I've gone back and forth myself.
mm-hmm.
One of the I'm always kind of stuck to the idea of like slippery slope and want to make sure that we don't ever get into a situation where it's like where does this end? That's something I feel strongly about. At the same time, I feel more strongly about the idea that the police have to do a perfect job. We should expect perfection from law enforcement, especially when people's lives are on the line. And as we review some of this evidence and we recognize that the police could have asked additional questions and they could have done more to determine whether or not he was explicitly waiving his rights, I'm inclined to believe that because the police did not do a perfect job or a near perfect job in investigating this, that evidence should not have been admissible. Because we can't, because you're right, as we go round and round, this does somewhat prove to me that it is pretty difficult to ascertain exactly why he didn't sign the form. And because we don't have that answer, I don't feel comfortable agreeing with myself from 15 minutes ago.
Yeah, that version of you is a real asshole, and
Yeah.
I did not like him very much.
I agree.
So I'm reviewing the facts of the case again, and I'm realizing that he admitted in court that prior to his arrest he had been drinking. That actually makes me feel like consent was not obtained.
Wait, was it prior to his arrest, or was it prior to
it was prior the day of the crime?
Oh, okay, I mixed that
he
up.
was drinking.
Because when he was observed by the agents, he wasn't under the influence.
I see.
He was drinking for 4 months straight.
I mean, we don't know that, but it's
we
plausible.
don't not yeah we yeah.
Okay, so that's out. I'm looking for outs for this guy. I just want him to get a chance to rob a gas station and just see how he really performs. He didn't get his chance the first time, ostensibly.
It was just an idea.
Yeah, it's just a crazy concepts of a plan.
Jesus.
And so the effect of all this is like, dude is free on the streets. Like conviction overturns.
Yep.
That's the end of it.
Well, that's a good question. I can't remember, Nikki, did the North Carolina Supreme Court overturn the conviction, or was it like you would have to retry him? Or does
let
double
me
jeopardy enjoin at that point?
hang on. I'm gonna go and pull up what I have here. So the Supreme Court, the new North Carolina Supreme Court, reversed the convictions and ordered a new trial.
Okay.
And
okay.
yeah,
So he would be retried, and I assume the argument would be that evidence would be excluded so the prosecution could retry it, but the case they make would be altered.
All right, people, back to zero. We got to rearrest him. We're going to start from scratch, reading him his rights real clear this time. Give him
well,
the
let's start
form.
from scratch. I guess any evidence that wasn't related to his statements is still valid, right?
Correct. Yeah.
Yeah. Well, you know what? I think I've gone to they should have definitely had more explicit understanding on the waiver, especially if the retrying is an option.
But if they retry him, doesn't that just present the same issues as the first trial? They're just shifting the venue.
Well, no. I mean, if all the other evidence was solid, the testimony, there were other corroborating witnesses, physical evidence, right?
Okay, I see what you're saying.
Stuff.
Yep. All right.
I mean, it's in the back of everybody's head that this guy said all this stuff, so I don't know how you completely wipe that, but
That does seem kind of poisonous to the entire thing if it's supposed to be non-admissible. Yeah. But what are you gonna do? Got to break a few eggs to make a justice omelet. Okay, so I feel like we've all sort of like a bunch of discrete metronomes all come into sync now, and now we're all stuck on the left. We're all stuck on the left-hand setting because we're all.
And you know what this means, though, right? You know that if we're all stuck on the left, then the real Supreme Court is finna hit us with the right.
Oh no, yeah, they probably
For
rule this
sure.
guy like summarily executed in the court before like everyone goes home for the day. Like we're gonna really make an example of this guy. Show you appeal. Oh wait, I guess it was the state that appealed. Who appealed this to the Supreme Court? It was the prosecution.
the state, the prosecution.
Yeah, okay, yeah. They're like, we're really gonna get this guy. You vexed us for the last time. Yeah, I think we're ready to issue our ruling.
Hit us.
I think WB goes free to rob a gas station another day, or at the very least loiter and get ripped with his friends, which feels nice.
Or get tried again, I guess. He gets to go back to court.
Yeah. You go to the service station of your choice, WB, and you get some Mad Dog and you hang out with your pals. Just don't rob the place. We're keeping an eye on you, Buster. That's my ruling.
When we're talking about kidnapping and armed robbery and felonious assault, I expect the police to be able to prove that perfectly. Because that's someone's life. And we're throwing away this poor man's life.
Especially if there's a kidnapping.
Right.
If there's a kidnapping, it's like someone was kidnapped, right? And you should be able to find that person. And if they're not alive anymore,
the kidnapper should be able to say, it was that guy.
Right? Exactly. That should be pretty cut and dry. And if the kidnapped person is not alive anymore, that's murder. That's a whole other ballgame. Then you got a corpse, more material evidence. That's all I'm saying. Very flimsy case. Go get wrecked, cops. Do better.
I agree with the Chief Justice.
Chief Justice throwing down the law. Enjoy that, cops.
So, Justice Mike, any additional statements on the matter?
No, I agree. I think it needs to be explicitly obtained that you are waiving the rights or at least understand them. And I don't. Originally, I thought that was pretty clear in this case that they were understood, but I'm not so sure about that now.
All right. We have a unanimous decision for the respondent, for WB.
All right. Wow.
Now, but you guys saying go free, are you guys agreeing with the North Carolina Supreme Court that he to order a new trial?
New trial.
Yeah, the go free was a spiritual message.
Oh, okay.
Yeah.
Right.
Yeah. So my takeaway was that, let's see, from the Adam court, WB's statements are excluded. He must be retried. The police should do better.
Yeah, do better cops is really bold that part, please, if you have formatting options.
Print it on a t-shirt and distribute.
Yep, also quote me there as well.
Also tattooed on my person.
Yep, running out of space, buddy. It's got a lot of pithy phrases on your body. Just like anything novel.
If the robbery does not fit, you must acquit.
You put that there too. Literally any novel thing you hear, you just get tattooed on yourself, and it's both off-putting and very charming. Well,
all right,
we did
there
it justice, guys. Yeah, great job.
I suppose now you'd like to know what actually happened.
Would love that.
No, actually, not interested.
He went on to murder again.
I suppose now you know in your you know in your bones what really happened.
Yeah. Yeah.
Well, that's all, folks. It's been a great show.
I just got a lot of aggression against law enforcement to work out.
To be fair, okay, so the last one that three of us did, it was like very clear cut that the cops did the right thing. Like this, so
We rode this.
Yeah.
So my favorite part of all these is guessing what year was it. I'm going to guess this was late 80s.
I guess 2035.
2017.
2035.
No, it was 1979 was when the case is argued and decided. And then just for reference, Miranda was, I think it was 1966. Let me double check.
That makes a lot of sense. A bunch of guys loitering in a gas station and just literally deciding spontaneously to murder the clerk would probably be caught on video any time later than that.
Miranda was 66, yes.
Yeah. And this was a 5-3 decision. And the majority opinion starts out like the opening sentence talks about how the North Carolina Supreme Court's decision was, quote, in evident conflict with the present view of every other court that is considered the issue.
Wow.
Oh, all right. Wait, but that's the first sentence. So that, but
that's a polite way to say that.
But
the shade
got busy right away.
Yeah, that was, I literally wrote that in my notes. I'm like, shade? And then I read the following sentences and I was like, shade. Okay.
Yeah. It did not get better.
Yeah. So
and liberals on the checks notes. North Carolina Supreme Court.
So they were like, the Supreme Court was totally wrong in how it interpreted Miranda. And, they were saying like, when they said heavy burden on the government to prove that the guy knowingly and intelligent waived his rights and an express statement, they were like, we didn't say that an express statement is indispensable to a finding of a waiver. So, an express written statement, oral statement, that's certainly strong proof the defendant waived, but it's not necessary or sufficient to establish waiver. So really you have to look at whether the defendant knowingly and voluntarily waived the rights. So like silence plus an understanding of rights plus they call it a course of conduct indicating a waiver could be a waiver of rights. So actually, Graham's initial sort of take on the guy's behavior, that's kind of what they were thinking.
So if they say sign this and you're like, hell no, I'm not going to sign this thing that I clearly understand, that's a no. That's the inverse of signing it.
Yeah, so basically they were like, Miranda says that you just need to make sure that the suspect is informed of his rights when interrogated. North Carolina, the Supreme Court there, they're doing too much. It's clear that he was
dial
adequately
back
informed.
the justice guy.
Yeah, yeah,
basically. Down, boys.
Yeah. So, there's no reason to think that he didn't understand the rights just because he wasn't waiving the rights just because he wasn't explicitly saying that he was. So the court's like, you have to look at the quote, particular facts and circumstances surrounding that case, including the background, experience, and conduct of the accused. So we don't need to replace that with an inflexible rule. They also talk about how 10 out of the 11 U.S. courts of appeals and at least 17 state courts have held that an explicit statement of waiver is not required. So they're like, North Carolina Supreme Court has, quote, gone beyond the requirements of federal organic law. So North Carolina lost the popularity contest.
All right. So so you let us all know that you understand you waive your rights. Please write a short little limerick expressing that you understand that your rights are waived, and then we'll begin viciously beating the soles of your feet with reed.
You just hand the guy a flag with the word rights on it, and you can just like.
Oh yeah, please perform a 30-second interpretive dance with this flag to let us know that you have waived, in fact, your rights.
I would very much like a coffee table book of waiver haikus.
We'll get right on that. That's be our first piece of licensed merchandise.
So, but it was really like the dissent was actually, you know, a lot of what you guys were saying kind of came up. That at the very end of the one was just like, if the agent, quote, simply elicited a clear answer from WB to the question, do you waive your right to a lawyer? This journey through 3 courts would not have been necessary. So that was how the dissent ended. They're like, cops, if you'd like just done a little bit more, you know, we wouldn't have to do all this. But yeah.
But we're totally on your side anyway.
Well, that was the dissenting opinion. The dissent was like,
right,
yeah, they were like, you know, the court was the North Carolina court was correct to grant a new trial. There was no written or oral waiving of rights. You know, the Supreme Court talking about inferences from actions and words basically means that you can construct things from ambiguous words and gestures. And they're like, the premise of Miranda says that if there's any ambiguity, you interpret it against the interrogator, because custodial interrogation, it's comes with this inherent compulsion. You know, it's supposed to be subjugating the person's will. You know, so if you just have a simple rule that requires police to get an express waiver before moving forward with the interrogation, then we don't need to do all this interpretation and ambiguity and error. And they were like, this case shows why we need an express waiver requirement.
Yeah.
Got him.
Yeah.
Oh, keep
Go
going.
ahead.
Well, I was going to launch into some so what stuff, but not if you still have stuff to go through.
So yeah, there was some discussion because basically, according to legal scholars, this case sets up this notion of an implicit waiver of one's rights. So one can implicitly waive one's rights without doing some sort of express exact statement or written waiver. And although the ruling was basically saying like, only in some cases, it's not all the time that you can just interpret things. It's only in some cases where things are very clear. There's some psychological literature that weighs in on this that's very interesting. There was one study by Rogers and colleagues in 2010 where it was like, yeah, everybody says that they know their Miranda rights, but like we did a survey of people in jail and of college students, and there were some, you know, like chunks of people, like around 30 something percent didn't actually have like a full understanding the way that people thought they did. And this was independent of whether they had the, you know, hard knock school experience or the formal education and training. And then Melton and colleagues also summarize psychological research showing that, you know, once again, people don't understand the Miranda rights as well as they think they do. A lot of adults, I think Tom Grisso conducted research demonstrating that something like 23% of adults don't understand at least one of their Miranda rights. There's also, you know, depending on police interrogation techniques and the circumstances of questioning and certain vulnerabilities in people, such as mental illnesses or youth, minors under the age of 15 totally don't understand their rights. Reading comprehension, and there have been some studies comparing the Miranda rights warning with average levels of reading comprehension, you know. So there's reasons to kind of think about this and be concerned about how well do people in general know their Miranda rights.
Yeah, most people are pretty ignorant.
How well do the people on this call know their Miranda rights?
Well, I haven't been arrested recently.
So a couple of takeaways.
This was
or
a
some
good
thoughts.
refresher. So
Yeah, just don't sign the paper and you can get away with anything.
So first thought is, so we said Miranda was 66. This case was 79, right? So it's 13 years between those cases. I think the court in 66 was very different from the court in 79.
That was a question I had: is what was the justice overlap?
Yeah, exactly. And I probably should have done more research on this, but it kind of only just hit me as we were going through this, and I started looking at the dates. But my gut tells me, and any actual lawyers who are listening can go ahead and hit us up on Instagram or Blue Sky or whatever your social media of choice is, what we have chosen to
Facebook
implement
probably.
ourselves. But if you want to yell at us or send us letters or come on the show and explain this in greater detail, that would be great. But my gut
Please
tells me
help.
that please begging you. My gut tells me that the court in 66, which was the Marshall Court, was
No, it was
right?
the 60s. Oh, wait, I'm looking at the wrong one. Okay,
I
sorry.
think Miranda was Marshall, Chief Justice Marshall.
No,
who wrote
Miranda
that.
was the Warren Court.
Or Warren, sorry. So I think the Warren Court was looking at a landscape where there was like no assertion of rights in the process, and they needed to remedy that. And Miranda was the case where they remedied that. And from that point, that was probably the high point of the rights that the court was saying, or the restrictions that the court was putting on law enforcement in order to protect the Fifth Amendment. And cases like Butler here are the future courts wrestling with walking some of that back, right? The Miranda was a great expansion of Fifth Amendment protection, and a case like Butler is a contraction of that. Because if any court could have looked at Miranda and said, "Whoa, whoa, whoa, whoa! This says like knowingly and intelligently. Like we need to be absolutely sure of this." If that was what they understood it, and that's how the North Carolina Supreme Court did understand it, and then it gets back to the Supreme Court. The Supreme Court saying like, no, we're going to contract the definition. We're going to contract the ruling a little bit. This is not the only case like this, and I won't go into any more detail about it because we may do other cases like this case in order to compare and contrast.
Spoilers.
But there is a, I think that is for me sort of the theme.
Mm-hmm.
I had the same sort of back and forth that the justices did when I was reading the case, because it's like, shut up, man.
Yeah.
We just never talk to the cops. That's like, come on.
Just shut up. Yeah. But at the same time, like, this is a thing I learned long ago in the corporate world as a manager. Like, when you give somebody a task, you never ask them, like, do you understand? Because the answer to that question is always yes. Because nobody wants to admit that they don't understand. So it's a terrible question to ask. The better question is, explain it back to me.
Mm-hmm.
Right? But this is not what the police do, right? And it's not what they're trained to do, so like
it's not what they're there for.
It's not what they're there for, right? And so like part of me was like, and I've said this to Nikki before as we've been talking about cases, is like I have a problem with Miranda, or the Miranda rights generally, and it's not that they exist, it's that the cops say these magic words, and then they're free and clear from that point out.
Mm-hmm.
It should be, to me, now I'm just getting into my personal opinions here, but the government has all of the resources. Make the government prove it. Make the government, like, we can study this. We could figure out some implement in order to, like, we do this for mental health all the time. We have people whose jobs literally is to assess competency to stand trial? Do they really understand the law?
And to waive their Miranda rights. That's also a thing that gets assessed. Yep.
Exactly. Yeah. So to me, as I was reading this, that was kind of my first opinion, where I was just like, first opinion was like, dude, shut up. Let's read through this. And then
100%.
secondarily, it's just like try to put myself in the position where, like, I think about this stuff a lot, but if the cops showed up at my house and took me away and I was just trying to get home, or, like, again, it's similar to, like, prosecutorial discretion, right? It's the enormous amount of energy that the government can bring to bear on you to completely upset your life. Maybe it's worth saying, like, yeah, make their job a little tougher. Make law enforcement a higher paid, more skilled job, maybe, right? Like, I don't think that that's a bad thing for society. So I kind of went either way on this case myself.
A couple things to add. I was kind of informally looking at the composition of the court. So in the original Miranda case, Justice Brennan was on the court. I think it was the only one who was on both Miranda and in Butler. And what I will say was that he was pretty consistent the whole time. So he was part of the dissent in Butler, being like, what the fuck, guys? Like,
yeah.
Miranda is trying to protect rights, and, like, if the cops had just gone the extra step. If there's any message for the listener, I think it would be just don't talk to the cops.
Do not talk to the cops.
But we're not lawyers also. We can't give legal advice. But as friends,
it's just good life advice, really.
Shut up.
Just good life advice. Yeah. Shut up.
Be quiet.
Yeah. Even if you didn't do anything.
Shush.
Yeah.
They'll figure out some way to make it so you have.
Just a general rule of thumb in life. Just say less.
Yeah. So two important pieces of life advice I've gotten from this. One, don't talk to the cops, and never sign anything.
Yeah.
Yep.
That's the first two steps of sovereign citizen stuff. Yep.
Oh.
Never talk to the
wait
cops.
a second.
Never sign.
Wait a
Oh,
second.
no.
Wait.
Oh God. Oh no.
What do you mean I was driving? I was traveling in this vehicle.
Oh God.
There's no fringe on this flag.
Officer, you weren't wearing your hat. You're out of uniform. I've heard that one from non-sovereign citizens.
Really? Wait, what does that have to do with anything? I
don't know. Lawyers of the internet, of podcast land, let us know. Is there anything there? If the state trooper shows up without that wide brimmed hat, are they out of uniform and therefore not capable of dispatching their duties? If they're wrestling me to the ground and I knock their hat off, are they no longer law enforcement?
If they walk up to your car and they're like, "Sir, do you know how fast?" and then, like, a gust of wind, you have to go, like, forget it, and then just walk back to the car. Like,
yeah, in relation to the spin of the Earth or the galactic arm of the galaxy. I'm moving at 7,000 miles per hour.
Yeah, relative to which fixed point in space, sir or madam?
And you had to say sir or madam no matter who's in front of you, because you don't want to assume.
Just part of sovereign citizen stuff, man. You wouldn't understand.
And I don't. Nikki, I think you got to take us out of this one. Or we're just gonna go
just hard hand.
Yeah, just like, hey, thanks, GTFO.
Yeah.
What's the podcast equivalent of a cut to black?
So there we have it. The Adam Court has decided that the cops should do better. I think that was the takeaway.
Yes.
And I think this group of friends is also saying, as friends, not lawyers, we're not lawyers, don't talk to the cops and don't sign anything.
Ever.
Ever.
As your internet lawyer, all of you listening, I advise you to never sign anything.
No. He's not saying that as a lawyer. He's saying it as a justice.
No.
A sovereign citizen.
No.
The powdered wig has gone to his head. What have we done?
You're all fired except Graham.
Thank you.
It's the talc. Once
Hey,
again,
what
it's
did
the
I
talc.
do?
It's not what you did, it's what you're planning.
Okay, that's got to be another court case because that.
All right. Thanks, everybody. Thanks for being here. Thanks for listening.
Thanks for having us.
We'll catch you in the next one.
Bye, everybody.
And there you have it, a unanimous decision in favor of WB. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Research was done by me. Thanks for listening. Please subscribe, rate, and comment so other people can find us. For complete episode information, including references, please check out our website at relitigated.com. You can also catch us on YouTube, Instagram, Facebook, Threads, and Blue Sky. Please help us spread the word. All right, until next time, I'm Nikki, and this has been Relitigated. Bye.